Big news just dropped in one of the most talked about legal disputes in NASCAR's recent history. With the trial set for just 2 months from now, things are heating up fast. Industry legends like Joe Gibbs, Rick Hendrick, and Roger Penske have stepped into the spotlight, publicly urging all parties involved to find common ground before this lawsuit ends up in court. But what's really at stake here? And how could this case change the future of stock car racing? Let's break it down. The NASCAR charter system was introduced to bring financial predictability to team owners and ensure guaranteed race entry. Prior to this, smaller teams faced an uphill battle every race weekend, spending heavily just to attempt qualifying, with no certainty they'd even compete. When NASCAR rolled out 36 charters in 2016, it marked a major shift, giving teams franchise-like security, much like what you see in professional leagues such as the NFL or NBA. Each charter came with a suite of benefits, a guaranteed slot in every race, a share of broadcast revenues, and the option to sell or transfer the charter. Over time, some of these charters became incredibly valuable, trading hands for more than $10 million. While the system created long-term stability for many teams, it also centralized a lot of power within NASCAR, effectively giving the organization significant control over which teams got to race. This concentration of authority is at the heart of the ongoing legal conflict. In December 2024, 23XI Racing, co-owned by NBA superstar Michael Jordan and NASCAR driver Denny Hamlin, joined forces with Front Row Motorsports to file a lawsuit against NASCAR. The claim: NASCAR engaged in anti-competitive practices that violate the Sherman Antitrust Act, a federal law designed to curb monopolistic behavior and promote fair competition. The lawsuit argues that NASCAR's control over sanctioning and race entry, particularly through the charter system, unfairly limits competition and blocks teams from exploring other racing opportunities or negotiating more favorable terms. In response, NASCAR moved quickly in October 2025, filing a motion to have the case dismissed before trial. NASCAR's legal defense hinges on the timing of the claims and the contractual agreements teams signed. They argue that the statute of limitations for these antitrust claims is 4 years. And since most of the challenged conduct occurred between 2016 and 2019, the lawsuit was filed too late. Additionally, NASCAR points to release clauses in the original 2016 charter agreements, which effectively waived the right to sue NASCAR over these contracts. The defense also criticizes the lawsuit for lacking clear details on what illegal behavior took place and the damages sought, making it difficult for a jury to properly evaluate the case. NASCAR further highlights that the plaintiffs admitted they weren't aiming to create a rival racing series, undermining claims of being shut out from fair competition. In a public statement, NASCAR framed the lawsuit not as a genuine antitrust issue, but as an effort by a few parties to renegotiate deals they had already accepted. The organization specifically called out Curtis Polk, a key figure at 23XI Racing and longtime Michael Jordan business partner, accusing him of orchestrating collusion among teams to leverage better contracts. NASCAR's statement closed strongly, warning that neither personal gain nor bruised pride justified attempts to dismantle a sport built by thousands over decades. The reaction from the wider NASCAR community was swift and vocal. Many team owners submitted formal statements backing the charter system and urging a peaceful resolution. Roger Penske defended NASCAR's approach, noting that the introduction of the next-gen car in 2022 reduced his team's costs by lowering the number of cars required and standardizing parts. Penske explained that parts standardization has helped level the playing field, making competition fairer and expenses more manageable. He also mentioned his adoption of a similar charter-like model in the IndyCar series to provide stability and protect team investments. Brad Keselowski chimed in, conceding that the 2025 charter negotiations didn't satisfy all demands, but he described the final deal as a fair compromise that benefits the sport long-term. He shared a personal anecdote about racing in the SRX Series, a rival league, in 2023, while still competing and co-owning in the Cup Series. NASCAR did not prevent him from participating, which he used as evidence that the organization isn't operating as a monopoly blocking competition. Still, some owners express concern over the lawsuit's impact on the sport's future. Gordon Smith of Hayek Motorsports voiced worries about the ongoing uncertainty and potential fallout. Rick Hendrick, NASCAR's most successful owner, warned that undoing the carefully negotiated charter agreements could cause severe damage. He pointed out the dispute's reach extends beyond teams, threatening the livelihoods of mechanics, engineers, sponsors, and racetrack owners alike. Joe Gibbs found himself in a complicated spot, given his team's alliance with 2311 Racing, one of the plaintiffs. This relationship puts him in a tough position, as one of his partner teams is suing the governing body of his own racing operations. Nevertheless, Gibbs joined other owners in calling for an amicable resolution, emphasizing that the long-term health of NASCAR should take precedence over any short-term business disagreements. Judge Kenneth Bell has taken a cautious stance throughout the proceedings. He's shown reluctance to make swift decisions and has consistently encouraged both sides to negotiate settlements outside of court. Earlier in the case, he delayed rulings until NASCAR agreed to modest rule changes that eased tensions, signaling a preference for compromise over courtroom battles. Most analysts expect Judge Bell to allow the case to proceed to trial in December, but continue urging the parties to reach a settlement beforehand. The teams suing NASCAR accuse the organization of monopolistic practices, claiming it controls the tracks, series, and rules dictating who races and where. A victory for the plaintiffs could force NASCAR to sell some of its racetracks or parts of its series operations. They're also pushing for fewer restrictions on where teams can race and how the next-gen car can be used outside NASCAR-sanctioned events. One of their key demands is permanent charters, guaranteeing spots in races and increased financial security. They also seek greater input in NASCAR's decision-making processes, though specifics remain unclear. NASCAR has hinted that if the lawsuit escalates too far, it might scrap the charter system altogether. This threat has unsettled owners like Rick Hendrick, Roger Penske, and Richard Childress, who have all submitted formal statements supporting the current system, not because it's flawless, but because it provides predictability for years to come. Without the charter system, teams would have to qualify solely on performance each week, risking the value of existing charters plummeting overnight. This potential shakeup has united many fiercely competitive owners in support of the system's continuation. As always, if you found this breakdown helpful, don't forget to like, subscribe, and hit the notification bell so you won't miss any future updates.